Welcome back to the channel again. Third time's a charm today, apparently. Be careful what you wish for because I just said there's no news, new news today. And then we get news in my email the moment I log off earlier. But let's have a look. This is new from Leslie Sloane. Leslie Sloane is requesting a stay of discovery. Leslie was like, girl, I see you, New York Times. You got it. I want me some of the stay of discovery. And she is submitting her plea to please leave us out of this. Remember, we are women. We are a woman-run company. What are we even doing here? And they are asking us for way too much. This is a lot of work. Let us out of this. So let's have a look at what is going on here. So again, stay of discovery. We're not going to read it word for word. I would say I'm going to give you the two biggest points right off the bat. Number one, burden of discovery. She's saying the Sloan parties have, they have this excessive burden placed on them because Wayfarer and Freedman has come with 370 requests for document production and 18 interrogatories. I don't know, 370 requests for production of documents doesn't seem like a big deal when you are in the middle of a case like this. But what do I know? And the other big one I would say is the confidentiality concerns coming up again, right? These concerns about sharing the sensitive business information, especially since the opposing parties are direct competitors. We can't have them taking all of our secrets. And which I feel like wasn't that the whole point of the attorney's eyes only? But anyway, and they also feel as though because they have pending motion to dismiss, they feel very strongly that it's going to be granted. So why even start this if we're going to be granted anyway? All right, let's have a look, guys. This was just filed today, March 17th, 2025, regarding Lively and parties versus Wayfarer Studios and their parties. Dear Judge Lyman, we represent Leslie Sloan and Vision PR, Inc. in the above caption action. Pursuant to Rule 7, paragraph 1C of the court's individual practices, we write to respectfully request that the court stay discovery as to the Sloan parties until the court resolves their pending motion to dismiss, which is now fully briefed. The parties conferred about this request in good faith. Miss Lively, Mr. Reynolds, and the New York Times Company consent to this request. Well, yeah, of course they would. Wayfarer Studios, LLC, Justin Baldoni, Jamie Heath, It Ends With Us Movie LLC, Melissa Nathan, Jennifer Abel, Steve Sarowitz. Together, the Wayfarer parties oppose. Courts have considerable discretion to stay discovery pending decisions on a motion to dismiss upon a showing of good cause. So I think they're just also leaning into the whole situation with the New York Times. They list Cohen versus United States 2022. In exercising that discretion, courts consider 1, the breadth of discovery sought, 2, any prejudice that would result, and 3, the strength of the motion. Here, each factor strongly supports a stay of discovery as to the Sloan parties. First, the discovery sought as to the Sloan parties is unduly burdensome. The Wayfarer parties served a striking 370 requests for production of documents and 18 interrogatories on the Sloan parties. Each document request seeks all documents and communications concerning a wide range of entities and individuals, as well as all of their employees, representatives, agents, subsidiaries, affiliates, accountants, attorneys, successors, predecessors, and interest, and anyone else acting or purporting to act on behalf and anyone on whose behalf he is acting, several of which have no discernible relevance to this case. They go on to list proceedings with such sweeping discovery will unnecessarily drain the Sloan's party's resources, is what they're saying here. Spencer Trask Software and Info Serves LLC versus R Post International, considering that resolution of their motion to dismiss may obviate the need for burdensome discovery. So now they're just listing different cases. Further, as Your Honor recently observed, the burden of discovery is compounded by the sensitivity of the documents that will be requested. Here, discovery is particularly burdensome because several of the Sloan party's direct business competitors are parties to this action, and discovery will necessarily include confidential and sensitive business. As the court held in its recent order concerning the New York Times, well, there it is. I'm going through this. I just skimmed it before. They are referencing that. As the court held in its recent order concerning the New York Times, its ruling on the pending motion to dismiss could drastically affect the scope of discovery as to the Sloan parties, because the dimensions of this discovery that's permitted may vary depending on whether they are a defendant or third party. It does make sense. In brackets, the sheer breadth of discovery against a party cannot be said to be comparable to the discovery that will be warranted should the motion to dismiss be granted. The Wayfarer party should not receive the benefit of the less stringent standards for party discovery simply because they improperly named the Sloan parties in this action. Did they, though? I'm actually asking that, though. I'm not being a smartass. Did they? Any lawyers? Were they improperly added? Even if the court dismisses only some, but not all of the claims against the Sloan parties, its ruling would affect the relevance of many of the Wayfarer parties' document requests and thus drastically narrow the scope of the party discovery. They list some more cases. Second, the Wayfarer parties will suffer little to no prejudice from the stay. A delay in discovery without more does not amount to unfair prejudice, is what they're saying here and referencing different cases. The court has already indicated that it intends to decide the pending motions to dismiss quickly. Hopefully, so that we can get things moving. I hope this is done quickly. A little pep in the step. Let's get her done. The court has already indicated. Okay, we already did that. All right. Additionally, the Sloan party's role in the overall dispute is small. This is what is so interesting to me, that they're also like, we didn't even know she was being harassed. We didn't even know this was a thing. Leave us out of this. We had no idea. Additionally, the Sloan party's role in the overall dispute is small. Miss Lively's amended complaint discloses that Miss Sloan was not even aware of the sexual harassment as it happened. I want to know who was aware. Blake, where are those text messages to your bestie Taylor Swift? Where are the text messages to Gigi? Where are the text messages to Ryan saying this guy is such a creep? I am disgusted by him. Where are those? Because I feel as though if those text messages existed, she would have brought them forward. I can't imagine having a smoking gun of this string of text messages to Taylor Swift talking about how awful she was being treated by Justin Baldoni on set, what he was doing to her, the boundaries he was crossing, how she's so uncomfortable and no one will listen to her. I cannot imagine if those texts existed that they would not have been added to the original complaint and the New York Times smear campaign article. You wouldn't need doctored text messages if you had those. So I just find it like, I mean, she's even saying here, I wasn't even aware this was going on. No one knew, apparently. And the Wayfarer parties do not and cannot allege that Miss Sloan was involved in the New York Times article that they claim is defamatory. Well, it seems like they are saying they want to amend their lawsuit because they can prove that you were involved, Leslie. That's what I seem to be getting from everything that's come out in the last few days. Instead, the Wayfarer parties allege only that Miss Sloan sent a sum total of 2 text messages that they incorrectly claim are defamatory. I mean, is she going off of the old information? Because I could have swore that we've learned that she was more involved. Am I losing it? I could have swore that Justin's lawyers, we're going to have to bring it up quickly after this. That they have evidence now that she conspired with Blake and Ryan to make Justin the scapegoat. I don't think I'm going crazy, but I don't know. This case might make you go crazy. We'll bring it up after we go through this. I think she's like, get me the hell out of here before this is involved. I just out. You know, actions have consequences, my friend. And y'all should have thought about this before you try to take a man down to protect yourselves. All right, where were we? The main parties in this dispute, Miss Lively and the Wayfarer parties, will not be seeking stays and can proceed with discovery without burdening the Sloan parties. Indeed, the Wayfarer parties have already served extensive discovery requests on Miss Lively, Mr. Reynolds, and 10 third parties All right, guys, I want you to list in the comments, who are the 10 parties? Taylor Swift is number one for sure. She's on there. Who are the 10 parties? 10 third parties already. I'm going to say Taylor, Hugh Jackman, Bradley Cooper, Gigi. That's only 4. It's only 4. Who else? Because I'm guessing it's 10 outside of her. That's only 4. Guys, help me out. Who are the rest? All right. In the meantime, it's evident that the parties will be busy, you think, with document discovery from the other parties and with third-party discovery. I hope the judge doesn't grant this, but like also these arguments, I hate to say it, don't seem overly unreasonable. I mean, I do think they're going to be completely swamped with all of that, sorting through Taylor Swift text messages and emails. Third, the Sloan parties respectfully submit that they have presented substantial grounds for dismissal and made a strong showing that they're likely to succeed on the merits of their motion to dismiss. I sure shit hope not. The Wayfarer parties have conceded as much by declining to meaningfully defend the amended complaint as written, instead writing that they intend to move for leave to amend their pleading. The Wayfarer parties have clearly concluded that the amended complaint is indefensible and the Sloan parties' motion to dismiss will likely be granted. Am I missing a step here? I feel like I'm missing a step because I never got that impression. But it's very possible. There are a lot of moving pieces constantly. It is very possible I missed something. You guys will let me know anyway in the comments. Including because the Wayfarer parties note that their complaint may need to be amended to address issues raised by the motion to dismiss. As set forth more fully in the Sloan parties' motion to dismiss, the amended complaint is fundamentally defective, among other deficiencies. The Wayfarer parties engage in impermissible group pleadings, fail to plead the elements of their extortion, defamation, and false light claims, and fail to comply with the basic requirement of identifying or describing the statements they allege are defamatory. The staggering breadth of the Wayfarer parties' discovery request confirms their true intent to use discovery as a hunting license to conjure up a claim that does not exist. They're using, I like flew through that because I need to share what's on my mind. They're using what everyone said about Blake against them. They're basically using what Wayfarer and Justin's side said about Blake and Ryan against them now. They all seem to just use people's words against them and twist them. But allowing the Wayfarer parties to conduct discovery in order to piece together a claim would undermine the purpose of Federal Rule of Civil Procedure 12b-6, which is to streamline litigation by dispensing with needless discovery and fact-finding where the plaintiff has failed to state a claim under the law. Accordingly, the Sloan parties respectfully request that the court grant a stay of discovery as the Sloan parties pending resolution of their motion to dismiss. All right, there's a footnote here. The Sloan parties served initial discovery requests on the Wayfarer parties on March 14th, 2025 to comply with the case management plan and scheduling order ECF number 58, but will hold response to offensive discovery in abeyance the same amount of time a stay is in effect. So that is the motion to stay to stay discovery because she feels that they're just going to dismiss it anyway, that she's going to be let out. So she wants to stay. From my understanding of this, I'm not a lawyer. I don't even play one on TV. I don't even play one on YouTube. So, listen to lawyers on this as well. But it seems as though they're saying, you know what? There's too much work here. If we get started on this, not only is an issue with our competitors getting our information, maybe because they don't even need it, because we're going to be dismissed anyway. On top of that, we made a great case to dismiss. So just let's hit pause for us. So we don't have to do this, please. All right, but I want to look at something because I could have swore that there was just something that came out in regards to Bryan Freedman wanting to amend the lawsuit again. Hold, please. See, I knew I wasn't going crazy. Well, crazier than I already am. Crazier than this case is already making me. This was 6 days ago, March 11th. Justin Baldoni's lawyers claim Blake Lively's publicist made him a scapegoat to escape the actress's wrath. Publicist Leslie Sloane's attorney claims she was dragged into the legal battle to distract from serious allegations of SH. But Justin Baldoni's legal team is not backing down from this, including Leslie Sloane, the publicist who works for Blake and Ryan. The It Ends With Us director, actor 41, responded to Sloane's February 20th request to be removed from the lawsuit in a filing on Thursday, March 6th, which served as an opposition to Sloane's motion to dismiss. The Sloan parties played an active and integral role in the conspiracy to inflict harm on the Wayfarer parties, claimed the response, filed in the Southern District of New York. His attorneys also claim in the filing, in a desperate effort to salvage Lively's reputation and to escape her wrath, the Sloan parties conspired with Lively and consolidated defendants Ryan Reynolds and the New York Times Company to make scapegoats of the Wayfarer parties for Lively's woes. So what am I missing? Because that seems very different than what Leslie was just saying, but like they know we're not involved. What are you talking about? 6 days ago you were being called, actively involved in a conspiracy to blame Justin. I must have missed a step. They went on to allege, on information and belief, the Sloan parties worked for months to drop breadcrumbs and hints of sinister allegations to the public while secretly feeding defamatory falsehoods to any reporter who would listen. As a direct result of the actions of the Sloan parties and their co-conspirators, the Wayfarer parties have been damaged beyond measure, Baldoni's lawyers added. These are the facts underpinning the Wayfarer parties' allegations against the Sloan parties, and this is what the evidence will prove at trial. In a statement obtained by People, Sloan's attorney, Sigrid McCauley, managing partner of, I hate saying names, Boys Schiller Flexner, says, as our motion to dismiss makes clear, Leslie Sloane and her company Vision PR were dragged into this lawsuit in an attempt to distract from serious allegations of SH and systematic retaliation. The irony is not lost on us that Baldoni's team have wrongfully accused Leslie Sloane of engaging in the very same misconduct for which they stand accused. The claims against Leslie Sloane were brought as a baseless finger-pointing exercise, added McCauley. We look forward to settling the record straight on our grounds for dismissal and removing Leslie Sloane from this litigation, putting the rightful focus on the serious issues and allegations before the court. Lively, 37, originally sued Baldoni, his publicist, and crisis PR team, including Jimmy Heath, Wayfarer Studios, and his co-founder Steve Sarowitz, claiming SH an alleged retaliatory public smear campaign to destroy her reputation, which he has denied. Sloan and Vision PR were dragged, air quotes, into the legal battle as a smoke and mirrors exercise to distract from Lively's accusations of sexual harassment and retaliation. Sloan's filing from February alleged, arguing there was no basis for accusing her of planting malicious stories or launching a smear campaign. I don't know. It just seems very different than what Justin's side is saying. And I believe on Instagram, let me see if I can pull that up and I can share it with you guys. I believe I even had a picture of, there it is. Let me pull it over. You can follow me over at Ashley Brandon Eve over on Instagram. But this is from the filing here itself. And it says, so the premiere, so this is from Justin Baldoni's team. As the premiere of the film approached in the summer of 2024, Lively told Sony that she and the rest of the cast would not participate in any marketing or promotion of the film alongside Baldoni, deliberately creating the false impression that Baldoni had committed some serious offense. I agree. Blake she brought this on by all the speculation that was happening. On information and belief, Sloan was throughout this time working to spread false and defamatory allegations against the Wayfarer parties to members of the press, both defaming the Wayfarer parties and serving as a muscle behind Lively's course of threats. Upon information and belief, this began well before the backlash against Lively for her wrong-headed marketing efforts for the film, not to mention the self-promotion of her alcohol and hair care brands. The FAC details the information known to the Wayfarer parties at the time of filing about Sloan parties' activities to defame and extort them. Since filing the first amended complaint, the Wayfarer parties have obtained additional information about the Sloan parties' activities during this time and will, if granted leave to amend, add those allegations into their amended pleading. That was 6 days ago. But now she's saying something completely different. I don't know, y'all. All I know is I need a bubble bath and some food and water. Maybe a hot chocolate. That is what I need. What do you guys think? Let me know in the comments. Am I missing a step? Did I miss something? But it seems like we got this from Justin's side, and then we get this from Leslie Sloane, which she's like, I think it's going to be approved anyway. The motion to dismiss. We're going to get out of here. I want to hear what you guys think. I obviously have to be careful what I wish for because I was like, this is a slow news day for them. But here we are. We have the request to stay discovery. Do you think it's going to be granted? And do you think it should be granted? Those are two different questions, right? Do you think it will be granted? Do you think it should be granted? I am not a lawyer, but there are some arguments in here where I'm like, yeah, I mean, if they served it on 10 people, they're going to have their hands full anyway. And if there is a motion to dismiss, like, does it really harm anyone to just put it off? Probably not. I can see the judge approving it. But also, if Justin's team just wants to like go balls to the walls and get all the information from everyone right now, like, I don't understand why they should not be allowed to do that. But I guess if there is this motion to dismiss, and the judge is hoping to get it back fast, then I can also see that side of like, well, it might not move forward anyway. Maybe it'll light a fire under the judge to just like give a decision on the motion to dismiss. I don't know. I think girlfriend should be just like dragged through this and she needs her day in court too. I do not think Leslie Sloane should be let out of this. But what do you guys think? Let me know. And I want to hear, who do you think those 10 people are? 10 people to start. Who are they? Let me know in the comments and I'll see you guys in the next one. Bye, guys.